Hello students, welcome to the daily news analysis. I am your educator Prithviraj Singh and we'll be discussing the important news articles of 16th of March 2022. Guys, Supreme Court would be pronouncing the judgment for OROP, one rank one pension scheme for the armed forces. We all know this scheme, and this actually talks about the one rank one pension. That means those who are in the same rank in the army, in the defense forces, those officers or the army personals who retire with the same rank and who have served the same length of services in the in the forces would get the same pension. Guys, the issue is actually with regard to the pay commissions. For example, let's say a person, an officer of, let's say, colonel rank, retired in the year 2001. He would be his pension would be decided by 6th pay commission, whereas a colonel retiring in the year 2022, his pension would be decided as per 7th pay commission, right? So definitely the pension of the person who is retiring in the year 2022 would be higher than the officer who is retiring in the year 2001, right? Because of the different pay commissions, right? So therefore the army personnel had petitioned into the Supreme Court a few years back, saying demanding that those who retire from the same rank, those who have served the same length of service, must be given the same pension. So this was a demand was coming from many years, and the government did accepted this demand and came up with the policy of one rank one pension, or OROP, for the armed forces, right? Now there is a petition being filed in the Supreme Court claiming that the implementation of OROP has been faulty, right? Has been faulty, and in this sense the petitioner says that it in turn would create a separate class among the personnel equally situated in rank and length of service. The petitioners have challenged the OROP, and they've challenged the government's stand that equalization of pension would happen periodically every 5 years. So this is a clause which has been contested by the petitioner. The clause which talks about the equalization of pension, right? That means the pension would be equalized every 5 years, right? So it would be equalized periodically every 5 years, right? And in this sense it is unfair, right? Because this is a very huge gap. The gap of 5 years would leave them to a great disadvantage, right? And the petitioner said that the periodic equalization would cause great injustice to the servicemen, the war widows, the veteran widows and their families, by creating, instead of one rank, different pension scheme, right? So instead they are saying that the equalization scheme, or the equalization, periodic equalization, where the pension would be equalized every 5 years, would actually increase the gap, because it is a very long time period, and in this turn it would result into one rank different pension, and actually killing the objective of OROP scheme, right? So the Supreme Court is to pronounce judgment on OROP soon. Guys, if I talk about the OROP, we know that it is the payment of uniform pension to the military personnel. So those who retire with the same rank and who have served the same length of service, irrespective of the date of retirement, right, would be given the uniform pension. I hope you are getting my point. So those officers who retire with the same rank and who have served the same length of services must be given the same pensions, right? In my example, I said that if an officer is retiring, let's say colonel retiring in 2001 and a colonel retiring in 2022, would be receiving different pensions because of the different pay commission guidelines, right? So therefore it is unfair, and they say the petitions argued that there must be uniform pensions, and which was also accepted by the court, right? So in this sense we have understood the concept that and the government accepted this, saying that any hike in pension rates to be automatically passed on the past pensioners. That means if there is any hike in the pension rates, it has to be passed on the past pensioners, those who retired earlier, right? So, but the problems in this scheme is definitely, the first is the financial problem, because the government has to bloat its expenses. There is also administrative hurdle. Why? Because there is a huge task to pass all the benefits with no cutoff date. There is also legal hurdles. This will lead to similar demands by other government employees, especially the paramilitary forces, right? Now, why it is being demanded? Because of the reason that I mentioned, right? The term and the conditions of military service much tougher than the civilian one, right? So this is the reason that I mentioned, the different pay commissions, right? Now, the retired soldiers of the same rank and service should be given the same commission, right? So I hope it is clear, right? So I expect a question on OROP, one rank one pension scheme. Guys, moving to the next news article, we all know that recently the Kerala High Court, used the way of sealed cover jurisprudence in the Media One case, right? Guys, Media One is a television channel in Kerala, and it was being banned by the central government, right? When the petition was filed in the Kerala High Court, the reason behind banning the media channel was given by the government to the court in a sealed envelope, right? Quoting that it is confidential, it goes against the security and integrity of the nation, right? And the Kerala court gave a judgment and put a ban on the Media One television channel. Now, in these instances, the plaintiff, that means the party whose rights are violated, in this case Media One television channel, cannot ask for the reasons why their channel was banned if there is a sealed cover jurisprudence. Guys, the Supreme Court has steered into the practice of sealed cover jurisprudence, right? Now, the court, apex court, in the previous cases has also said that the government would not get a blanket immunity when they use the sealed cover jurisprudence, and it is not something to escape the fault of the government. However, there are no laws which actually regulate the sealed cover jurisprudence. Definitely there are some Supreme Court rules and the some clauses in the Indian Evidence Act of 1872, which actually gives the legal backing to the sealed cover jurisprudence. We also covered this article in some previous DNAs. It is stated under the said rule that if the Chief Justice of the court directs certain information to be kept under sealed cover or considers it of confidential nature, no party shall be allowed to access the contents, right? Similarly, this is also mentioned in the Evidence Act. Guys, in many other instances, the information may be sought in secrecy or confidence when its publication impedes an ongoing investigation. Now, let us explore some issues which were there in the past where the sealed cover jurisprudence was used. Now, in the case pertaining to Rafale fighter jet deal, which the Rafale fighter crafts which we procured from France. Now, the details were not being shared by the government, and they were shared with the court, the Supreme Court, in a sealed envelope, right? And whenever there is a sealed envelope, it can be accessible only to the Chief Justice and the judges dealing with the case, right? And they would never disclose the content mentioned in the envelope, right? And they would directly come up with the judgment without actually giving the reasons, right? So therefore it is very controversial, and this I would say in the garb of national security, the government, and the garb of Official Secrets Act, government actually violates many fundamental rights like Article 19, which is right of freedom of speech and expression. If a person is not able to know the details, not about to access information, it is a clear violation of Article 20, Article 19. It was also used in National Register of Citizens, NRC, when the Supreme Court mandated the coordinator of NRC, Pratik Hajela, and he was asked by the apex court to submit periodic reports in sealed cover. Similarly guys, when there was a case of CBI directors Alok Verma and the special director Rakesh Asthana, where there were counter allegations of corruption against one another, Supreme Court asked the Central Vigilance Commission to give the details, to submit the details in a sealed cover, right? So it is not that it is being first time used in the Media One case, but it was also being used in NRC, Rafael and the CBI director case, right? Also in BCCI reforms case in 2014, also it was being used. Similarly in Bhima Koregaon case, the sealed cover jurisprudence was used, and in fact the Supreme Court relied on information submitted by the Maharashtra police in sealed cover. So therefore the petitioners were not allowed the access to the information, and it actually violates the rights of the petitioners, right, to have the access to the information. Similarly in many cases like the coal scam case, Ram Janmabhoomi case, 2G case, the very infamous death of Justice Loya, and even the case pertaining to the release of Prime Minister Modi's biopic. In all these cases the sealed cover jurisprudence was used. And there is a lot of criticism for the sealed cover jurisprudence, as it is not favorable to the principles of transparency and accountability of Indian justice system, and it enlarges the scope of arbitrariness, right? Because when the details are not being made public, there is a scope of arbitrariness by the court. And although guys it is also being contested that the state should be granted such a privilege to submit information in secrecy. Why? Because there are in-camera hearings already provide sufficient protection to the sensitive information, right? So it is there. I hope it is clear, right? Guys, very important, and I expect a question on this. Definitely sealed cover jurisprudence, as I said, obstructs the fair trial and adjudication, and in the 2019 judgment, very important, and I expect a question on this. P. Gopal Krishnan versus State of Kerala. By heart this case, remember this case, right? Take a note. 2019 judgment of P. Gopal Krishnan. P. Gopal Krishnan versus State of Kerala. The Supreme Court had clearly said that the disclosure of documents to the accused is constitutionally mandated. That means the government cannot use the sealed cover jurisprudence to actually evade the the transparency and accountability. So therefore P. Gopal Krishnan versus State of Kerala 2019, the apex court said that the disclosure of documents to the accused is constitutionally mandated, and investigation is ongoing, and said documents may lead to breakthrough in the investigation. So very important case, P. Gopal Krishnan versus State of Kerala. So this is all for today guys. I hope you enjoyed the session. Good day. God bless you. Wish you all the best. See you in the next class. Bye.